So the client has signed your contract and you are performing pursuant to that contract. But does this mean that the obligations that you have or that the couple has to you can never change? The answer is no. Of course they can change if everybody is on board. But what does that change? What does that amendment look like? What's the best practices for changing or amending a contract? Find out today's video. Hey out there, welcome back to Wedding Industry Law. My name is Rob. I am a wedding industry lawyer. Today we're talking about the concept of amending a contract the right way, the recommended way. And to kind of start off with, understand that a contract represents an exchange of promises between two parties for consideration. So I agreed to come DJ your wedding for 4 hours. You agree to give me $1,000. Okay. So these are promises that we're making that are now legally enforceable. Once the contract has been formed, typically that's it. They're legally enforceable promises that cannot change unilaterally. So one side can't say, well, I promised to give you $1,000, but now I think on my own, I'm just going to give you $1 instead. No, both parties have to be in agreement for there to be any changes to those obligations that are in the contract. So for there to be an amendment, a true change, a lawfully enforceable change to the contract, there must be mutual, both sides, consent to whatever that change is. So you could imagine that you could get mutual consent to change on a spectrum of pretty good idea to that's not a very good way to run your business. And what I mean by that is on the bad end of the spectrum, there is a concept in the law that says that your behavior may affect the obligations that are in the contract. So by behavior, I mean, if you take your payments, so let's say that you take 3 or 4 payments during the duration of the contract. If you take those payments late by 20 or 30 days, the first 2 times, then that might mean to some judges or juries down the road that you have now amended that contract such that the next payment, the 3rd or 4th payment, it is okay to pay 25 or 15 to 20, 25 days late because your behavior has changed the perceptions of the obligations and therefore the obligations, just by way of example. So that's a way that maybe you didn't intend to change the contract, but you have done so. That's on the crap end. On the other end of the spectrum, you've got, everybody has to come into your attorney's office, your grandmother's there, it's videotaped, everybody has their own notary, there's the feathery quill, there's, sealed wax, it gets sealed up, put in a safe, this type of thing. That's on the other end of the spectrum in terms of how to memorialize the amendment or the change to the contract, okay? So the best practices are going to be somewhere in the middle, and that is to say that having a written document, it could be an e-signed contract or addendum, it could be a text message, it could be a WhatsApp message, it could be an email, some type of written communication from both sides representing that there is a mutual understanding as to what the change is, okay? So what I mean by that is it's not enough for there to be a writing that represents one person's perspective and not another writing from the other person. So an example of this would be you receive a phone call from your client that says, I want an extra 5,000 widgets. You say, okay, I could do an extra 5,000 widgets. It'll cost an extra $5,000. Okay. So what's going on is that before that phone call, you were not obligated under the contract to provide the client with an extra 5,000 widgets. Okay. So you couldn't be sued for not giving them an extra 5,000 widgets. They've called you and said, hey, will you do an extra 5,000 widgets? And because you said yes, and it'll cost you $5,000, that's an amendment to the contract. You've got a mutual consent. Both of you understand that there's going to be 5,000 more widgets for $5,000. Okay. So there's no writing though. So which means that, is it enforceable? Yes, if both people have perfect memories and understand that on, whatever March 2nd of 2021, there was a phone call XYZ. So getting a memorialization from both sides of the amendment. So after that phone call, you hang up, you email, text, WhatsApp, smoke signal, doesn't matter, to the client. Hey, great talking to you today on the phone. In that conversation, you said, let me get 5,000 more widgets. I said, no problem. I'll get you 5,000 more widgets. It's going to cost you $5,000. It'll be owed on this day, or whatever the terms of the payment are. Doesn't matter. Let me know if I got that wrong. Otherwise, you're going to owe $5,000 as of this date. Please confirm this understanding. Okay. That's the key. Please confirm that I got this correct. And then you're going to get an email back, or a WhatsApp message back, or a text message back that says, you got it. That's exactly right. The $5,000 is in the mail. The $5,000 is coming to your wire transfer, blah, blah, blah. And because you have both your confirmation of the change, their affirmation of your confirmation, you've got the mutual component, but also the written component. You've got mutual written consent to the change. And that's typically going to be very safe, and one of the better ways, not on the end of the spectrum with, everybody having to come in the office, execute new documents, being notarized or whatever. This is kind of like a pretty good way of amending your contract. Okay. Or it ends up, they email you back or text you back and say, no, you said you were going to get 5,000 widgets for $1,000, blah, blah, blah. And then what happens is that there'll be a chain of emails in which finally there should be some confirmation between the both of you of what the change is. Okay. So again, at the end of the day, you want a written document, a memorialization in some form that has both of you confirming what the change is. That is going to be the best recommended way for you to amend your contract. Then after that, you can further enhance, you can further reinforce the details of that amendment by maybe when you send for the $5,000, it's an invoice that actually has it written on there again, so that there could be no mistake. You're laying more foundation, providing more evidence for the fact that there will be 5,000 more widgets for $5,000. It's just a way of getting extra verification, although once the phone call occurs, technically you've got an amendment to the contract. But having the written affirmation is the best from both sides. So that's a very, very long-winded way to say how to amend the contract in the best way. If you enjoyed the content of this video, please be sure to like and subscribe. Leave a message down below. Have you ever been in a situation in which your client has wanted to change payment obligations or the scope of the work that you had originally agreed to, and you didn't feel like you needed to, or maybe you got, cheated out of something? Let me know down below. Let's get a conversation going. New videos every week on Monday. And with that, folks, we'll see you next time.